Okay, so we're going to be doing the 80 and 100 words per minute classes. I've been really neglecting steno practice lately. I just haven't had the energy to get out of bed. So I'm very glad that I streamed this because otherwise I would have tapped out again. Okay, 80 words per minute class.
Welcome to drill practice. Let's get started with these sentences. And the words in these sentences may be words that are easily confused, possibly. So, for example, we have in the first sentence, it talks about stationary. And so, as we know, stationary can be spelled two different ways, two different meanings. Stationary, like it's stationary. It's it's not moved. You can't move it. Or stationary, like you write a letter. So that's the types of words that are in these sentences. Okay, let's give them a try. Here we go.
He doesn't have her.
The seats
Huh?
in the theater. The seats in the theater are stationary. This note is on company stationery. A statue was stolen from the museum. He is a man of great stature. State statute forbids gambling. She is shorter than he is. We had lunch and then he left.
Okay, I'm a little slow today.
Well, hopefully that got your fingers moving. And also some of the words, like we had statue, we had stature, statute. 3 different words that you just really have to hear carefully. And
I'm not sure that you need to hear them carefully. Those are pretty different words.
Potentially confusing words in the sentences.
Definitely not confusing.
So good practice.
Statue, stature, and statute are completely different words.
Let's try a number drill now. Ready?
I'm not doing the number drill.
Here we go. 100, 0. All right, let's try these words that are, I guess you would say, for types of furniture. Types of furniture, yes. Okay, so just again, vocabulary development. Okay, ready? And let's see, these are actually in sentences. Here we go. Living room furniture includes couches, recliners, and coffee tables. Dining room furniture includes tables, chairs, china cabinets, and buffets. Bedroom furniture includes beds.
Why is there an ad break starting?
Chests, wardrobes, and nightstands. Refrigerators, dishwashers, and microwave ovens are common kitchen appliances. All rooms have lamps or lighting of some type. Drapes, blinds, and curtains are usual window coverings. Most households have a TV set, a stereo, and a DVD player.
Okay, that's no longer true.
Flowers, paintings, and sculpture are decorative items. So very, very good vocabulary development on that little drill there.
I'm so slow today.
All right. So now let's practice these words. Again, some of them might be words that you will brief or phrases that you may brief, and if not, please just write them out. Here we go. Authority, opportunity, quantity, quality, familiar, familiarity, material, materiality, necessity, identity, ability, couple, auto, automobile, difficulty, neighbor, labor, passenger, messenger, possible, possibility, probable, probability, respond, response, responsible, responsibility, reasonable.
Okay, give me a second. Responsible. Should have been able to write that. difficulty. Familiarity. Necessity. Okay, they're all 3 strokes. Messenger. Okay.
All right, that will conclude.
Wait, that's the end of the drill practice. My God. I didn't know that. Okay, let's move on to the jury charge and literary.
Welcome to literary and jury charge practice. Well, let's get started with some literary from our Who Moved My...
I'm not doing the cheese book. Move on.
Ready? A motion is often filed to reduce the bail that has been fixed by the court. The motion is made to reduce the bail, stating the grounds upon which it is made. It must be filed within the time prescribed by law. The real purpose of bail is to ensure the attendance of the accused at all required court appearances. If it can be shown that the person lives or works in the immediate area, or perhaps owns property in that area, the person's chance for bail increases. In many cases, the amount set by the court is high, considering the accused person's financial status, the nature of the offense, and other facts. It is important that there is a surety for bail. Before questioning, the suspect is advised of his constitutional rights to remain silent and to have an attorney. At the discretion of the court, bail may be posted by a surety. A surety is a person who ensures that the defendant will appear. Any person who is allowed bail may also be released without posting bail at the discretion of the court. If a person who is allowed bail is released on his own recognizance at the discretion of the court, that means that he is released on a promise to appear. A person also has the right to produce evidence and to have the court issue a subpoena to bring into court.
Tina, bean. Okay, we're done with that.
So we had a couple of words here that
I did it.
Might have been a little challenging. We had recognizance, and discretion.
Easy.
Discretion.
It was easy.
So some words to practice. We also had constitutional and subpoena.
Bean.
Right at the very end there, subpoena.
It's bean.
Okay, let's get back to some
No cheese.
material from our book.
No.
Some literary material.
Okay, let's skip that and
At the discretion of the court, bail may be posted in cash or by a bond. The person who posts the bail bond is called a surety or bondsman. Individual sureties are persons who own real or personal property within the state. They must have a certain net worth. A motion is often filed to reduce the bail that has been filed by the court. The motion is made to reduce the bail, stating the grounds upon which it is made. It must be filed within the time allowed by law. The real purpose of bail is to make sure that the accused will appear at all required court appearances. The judge can issue a bench warrant if the person fails to appear. In many cases, the amount set by the court is high, considering the accused person's financial status. If this is the case, the bail may be reduced. Before questioning, the suspect is advised of his constitutional rights to remain silent and to have an attorney. At the discretion of the court, bail may be posted by a surety or bondsman. A surety is a person who ensures that the defendant will appear. Any person who is admitted to bail may also be released without posting bail at the discretion of the court. If a person is admitted to bail, is released on his own recognizance at the discretion of the court, that means that he is released on a promise to appear. A person also has the right to produce evidence and to have the court require all witnesses to bring necessary evidence to court. Many people do not even know that they have rights granted to them by the United States Constitution.
I had some trouble with that one. I don't know why.
All right, we have a few more minutes with our friends in the...
I'm not doing the cheese book. She took out the cheese book 3 times. And we only get so many minutes of jury charge? That's some bullshit.
Welcome to Q&A practice. Let's do a little warm-up, just some two voice. We'll have the defense questioning the witness. Ready? Then you left at 6:30. Is that correct? That's right. It was somewhere along in there. I don't know what time it was. All I know is that it was about that time. All right. When your car was parked on the filling station lot, you spoke to Stanley Strong and to Mary Warner. Is that right? That's right. Can you tell us about how much time was used up while you spoke to Stanley Strong and Mary Warner? Do you mean all together? Yes. Well, I would say maybe about 10-15 minutes. All right. I don't know for sure. Would it be fair to say that at about 6:45 you drove away from that filling station? Well, I don't know. Maybe somewhere along there. All right. And you went straight to the Regency room from that gas station. Is that right? That's right. Did it take you more than 2 or 3 minutes? Is that right? That's right. Did it take you more than 2 or 3 minutes to drive to the Regency room? I don't think that it took me that long. It was just a couple of blocks down Wilmington, isn't it? About 4 or 5 blocks down there, yeah. And you only spent a couple of minutes in the Regency room. I only spent about 5 minutes, like I said.
Regency room? Oh, okay. Well, it's apparently a word for real. I was thinking that it was a proper noun.
Yeah, let's do some practice from our transcript.
It's Regency.
Let's see, where are we?
Regency room. Wilmington.
Looks like it's just mostly the plaintiff attorney asking questions. Defense does come in occasionally, so we do have a little bit. All right, so let's start with the plaintiff.
Plaintiff.
Here we go.
Here we go.
Could you be specific? What materials? Rebar and stuff like that. This particular area right here, we haven't used a lot of it. We've used a little bit of it, but not a whole lot of it. And over a period of time, I'm sorry, I'm not even sure. We may be using this to drive our vehicles back and forth, but maybe not even that. I don't know what the boundaries are there. Let me give you a pink pen. Would you put in the fence that is currently on the south property? If you want to call it a fence, it's just jagged pieces. It's fallen down. It's not really even a fence. You might go 20 feet and then there's 10 feet of it missing. Before you do it, though, I want you to try the best you can to locate the fence or whatever portion thereof and take into consideration where you put the asphalt, your gate in the back, and the 2 areas you say you use on the easement. Would you put your fence line in there? Well, there's a piece that goes from here to here, and then there's some missing, and then there's some up to here, and there's some missing. So from here, it's all of the way back. It's a partial fence. Draw a horizontal line to those areas. Okay, you drew it off what this shows as the property line. Do you intend to do that? I'm not sure if it's on the property line. I'm not sure where that fence is. You're saying that's the property line. As far as I'm concerned, all this area is property line. I don't have any idea where the property line is. When you put the fence in, did you think it was placed on a property line? I didn't put any fence in. Your father put it in. It's not really even a fence. It's just odds and ends of stuff, and he just put it there to keep the people off the asphalt. At one time it was brand new, and he didn't want anybody driving in and out of there to get dirt and stuff on it. I don't want to confuse you with my use of the word fence. I'm not trying to say that it's a solid piece of wire. Whatever is there will stand for itself. What I was getting at is, do you have any knowledge of whether, when your father put in whatever fence is there, it was placed on the property line? No, I have no knowledge of that. Now, the areas which you say you use in the easement area, is that to the south of the fence? Is it to the south of the fence? Do you want me to re-ask it? The south of the property? Let me re-ask the question. You've indicated on the map an area called XM, which is an area you said you sometimes use in the easement area, correct? Correct. Like I said, I don't know how far this line is.
How long was that? Oh, okay, that was the rest of the video. Tried to test. I missed a few sentences because I got stuck on whatever.
This will be
the word
an
whatever.
Q&A practice test.
Practice test.
Plaintiff attorney is Mr. Wilson, capital WILSON. Defense attorney, Mr. Jones, capital JONES. And it starts with the defense attorney. Ready? Asked and answered. You may answer. I really didn't see anything. Okay.
Whoops.
And it starts with the defense attorney. Ready? Asked and answered. You may answer. I really didn't. Asked and answered. You may answer. I really didn't see anything. Okay, and then now at this distance of around 500 or so, a little less from the scene of the accident, how far in front of you was the other van that this lady was driving that was actually involved in the accident as well. She was about 6 or 7 car lengths. And for how long had you been following that other van, the van that was involved in the accident? Most of the time, and you could see her clearly through your window? Oh, yes. And obviously you're not her, but if she would have been looking in her rearview mirror or any of the mirrors available, would you be at least as far as your state of mind? You would have been able to be seen as well? Yes, of course. Okay. Did you ever notice what she was doing in the car from the time you got on Main to the time where you were about 500 feet or so from the happening of the accident? Did you ever see her hands or no? Did you ever see her talking on the phone? I wouldn't have been able to see that. Okay. Did you ever see her do anything as far as that you could describe? Leaning over, doing anything like that, bending forward, hands not on the wheel, anything like that? Did you ever see, or if you weren't in a position to see that? I really was not that close to be able to see through a windshield to see what someone is doing in their car. Okay, so what you're trying to say is you just don't know what she was doing in her car? Yes. Okay. And then at some point in time, as you were approaching Morris Canyon, first of all, did you ever see the other van turn her turn signals on? No. At any time prior to the happening of this accident, did that other van ever have their turn signals on? Not that I recall. Not that you saw? Not that I recall. I don't recall seeing her light on. Did you see in the statement in here where you've indicated that the other person did not have their turn signals on? Did you read that? Yeah, I probably did. Yeah.
Woo! I did good on that test. Wow. This despite me not stenoing for a few days. Okay, let's move on to the second drill. 100 words per minute.
Welcome to drill practice. Let's get started with some tangle tamers. And what that means is we just have a variety of pairs of words, and that will get your fingers moving and get your fingers warmed up. All right, so let's give it a try. Ready? Quietly persuaded. Accessories available. Physical therapist. Professional community. Recently distributed. Undercover detectives. Hilly farmland. Densely populated. Widespread confusion. Adjoining library. Crippled communications. Separate proceeding. Magnetic forces. Structural foundation. Automatically canceled. Twice baked potatoes.
Potatoes. Structural. Next one, populated.
Let's move on to some names and spellings. Ready? Carolyn Lloyd. Lloyd.
I love it when the names don't show up.
Barbara Marie Kaye. Kaye. Peter Yaroshuk. Yaroschuk. John R. Arnold. ARNOLD. Kirby Margaret Slocum. SLOCUM. Daniel E. Ragland. RAGLAND. Michael Verhagen. VERHAGEN. David Ernst. ERNST. Bridget Lynn Stone. STONE. James Keck. KECK. Andrew Grove. GROVE. Joseph Cyril Carlin. CARLIN. Steve Blaze. BLAZE. Aaron Linder. LINDER. Daisy E. Tamez. TAMEZ. Christian Holloway. HOLLOWAY. Michael Ward. WARD.
My God, how long is this gonna take? Okay, we're done. Ugh, gone for so long.
Now let's try this drill, which is focusing on numbers and dates.
I'm over here hunching over my machine. Moved it up a little.
October 22, 2006.
Okay, I don't want to do just dates.
July.
I don't want to do just dates.
November 14.
Okay, we're just gonna move on. The jury charge.
Welcome to literary and jury charge practice.
If it was dates and sentences, I would be okay with it. But just dates and it was like 3 minutes long? Come on.
Jury charge.
My back hurts too much for that. I want to move on.
Ready? Here we go.
Okay.
The question arises as to when a person is actually in custody. If you are stopped by the police, you may be subject to being frisked. Being frisked is a search that is done to determine if you are in possession of a hidden weapon. Police have the right to search individuals to see if they are keeping weapons in their possession. Police have the right to see whether someone is hiding a weapon. This type of search is considered a legal search. The U.S. Constitution protects the individual against illegal searches. This type of search is considered a legal search. It is the type of search that may be conducted by the police. later, another search may be conducted of the immediate area to ensure that you do not possess anything illegal. Evidence may be taken at this time. The police have the right to conduct this type of search when someone is thought to have committed a crime. The police may not go into someone's house and conduct an illegal search. This type of search is illegal. The U.S. Constitution protects the individual against this type of search. This type of procedure is the legal procedure used by police officers who arrested an individual after the individual is thought to have committed a crime. Once the suspect was arrested, he was booked. Booking is a procedure used by police officers after they have taken someone into custody for having committed a crime. During the booking procedure, the police asked the suspect for information about himself.
Oh, I did good on that. Got some trouble with this over here. Immediate. It came out as Montana. Oh, it's PhD, not PhD.
All right, now for some literary material. And we'll get back to our NCRA member who rocked a radio interview.
I was actually afraid for a second she was about to say our cheese book.
Ready?
But no, it's from the NCRA journal.
I emailed Sean on February 2, and he responded 2 days later. The rest, as they say, is history. Mary Beth Johnson, CRI, Professor of Court Reporting at Community College of Allegheny County in Pittsburgh, Pennsylvania, and Amy Bolin, RDR, CRR, CRC, Imperial, Pennsylvania, former head of captioner training at VITEC, were totally on board when I asked them to participate, and we snapped up the opportunity Sean gave us. The date of May 18 at noon to record the interview. Although that was past court reporting and captioning week, we were thrilled to be able to talk about the profession we love. As a prelude to this interview, I gathered material that NCRA had available on its website regarding our profession, asked a few questions, and even reached out to NCRA past president Nancy Valero, RDR, CRR, Worcester, Massachusetts, about the connection between reporting and music. I also had pertinent information from a recent interview I had done with a local newspaper. I sifted through all of it and sent Sean some interesting facts and figures. He really did the rest. He was so thorough in covering the topics, and we reporters added comments throughout. Sean did a marvelous job hitting high points and seemed truly fascinated by what we do. Because the folks at this radio station are celebrities to us, we had a great time meeting some of them after the interview and touring the studios. All in all, it was a great experience.
I struggled with that one, especially because there were names in it. Always with the names.
Jury charge.
Back to some jury charge.
Ready? The principal is the person who is charged with this serious crime, but he did not commit the crime without help. The principal is said to have been accompanied by another individual who assisted in the commission of the crime. Someone who assists in the commission of a crime is known as an accomplice. The accomplice in this case is said to have been with the principal as he committed the crime of robbery. You must decide whether the defendant is the principal who committed the crime. You must then decide whether he had an accomplice and whether the accomplice is the individual named in this trial. You must determine whether these individuals acted alone or whether they acted with the assistance of the other who is named as a defendant in this case. If these two individuals did not act alone, you must decide whether they had assistance from someone who helped before the crime was committed. If they had help from an individual who assisted in the planning of a crime, then you must decide whether the individual in court is that person. The individual who assisted in the planning of the crime is known as the accessory before the fact. You must determine whether the accessory before the fact is the other defendant in this case. You must decide the case from the evidence alone and not from any other source. If this individual was not present but helped in the commission of the crime, He is to be considered an accessory before the fact. An accessory before the fact is not present when the crime is committed, but is still guilty of committing a crime. An accessory before the fact is never present when a crime is committed, but is still guilty. If the accessory before the fact helped the principal in planning the crime, then you must find him guilty of the crime. You have heard the testimony of these three individuals and the testimony of the other witnesses. You must decide who is credible. It is now your opportunity to decide whether the individuals charged with the crime are guilty of the crimes as charged. Your decision should be based upon the evidence in this case and not be influenced by other factors. You have heard the testimony of not only these individuals, but of all the others who had evidence to present to the court. After hearing the evidence, it is up to you to decide how to vote. You must not let others convince you in any way. You must base your findings on the facts, and the facts in this case alone.
I went on for a while. I was getting tired. My hand hurts.
Let's see what we have from Mr. Rogers.
Okay, the Mr. Rogers book. I'm fine with that.
This is called Fred Rogers' Acceptance Speech, Television Hall of Fame, February 1999. Let's see what he has to say. Fame is a 4-letter word, and like tape or Zoom or face or pain or life or love, what really matters is what we do with it. I feel that those of us in television are chosen to be servants. It doesn't matter what our particular job. We are chosen to help meet the deeper needs of those who watch and listen day and night. The conductor of the orchestra at the Hollywood Bowl grew up in a family that had little interest in music, but he often tells people he found his early inspiration from the fine musicians on television. Last month,
Okay, be right back. Ad starts soon. Okay, we're back.
On television. Last month, a 13-year-old boy abducted an 8-year-old girl, and when people asked him why, he said he learned about it on TV. Something different to try, he said. Life's cheap. What does it matter? Well, life isn't cheap. It's the greatest mystery of any millennium, and television needs to do all it can to broadcast that, to show and tell what the good in life is all about. But how do we make goodness attractive? By doing whatever we can to bring courage to those whose lives move near our own, by treating our neighbor at least as well as we treat ourselves, and allowing that to inform everything that we produce. Who in your life has been such a servant to you?
Got 4 more minutes. Broadcast. Oh, that has its own brief.
And get back to our jury charge.
Jury charge.
Ready? Here we go. You must keep in mind that you are not to be influenced by sympathy. You are not to be influenced by prejudice. You are not to be in any way influenced by the passion of any of the participants in the trial. Sometimes this is difficult to do. You must keep in mind what your duty as jurors is. As jurors, you must decide the questions of fact. You must also follow the law in the case. As judge, I will instruct you in the law that applies in this case, but you are to decide the questions of law. In this case, there are 3 defendants. The 3 defendants are the ones charged with the robbery. They are all charged, but not all will be treated in the same way with regard to the seriousness of the crime. The district attorney has brought forth the charges indicating that a crime has been committed. It is now for you as jurors to decide whether the evidence that the prosecutor feels shows that these individuals committed a crime is enough for you to find in favor of the prosecutor. If it is, you must find in favor of the people. As stated previously, you must not be influenced in any way by any sympathy that you feel for these individuals. You must not be influenced in any way by any prejudice you feel toward these individuals or any prejudice toward the attorneys who represent them.
Imagine convicting someone of a crime just because you didn't like their attorney. That's wild. Wonder if that's ever happened. Probably.
Welcome to Q&A practice. Let's get started with the defense.
Defense. Okay.
Ready? Did you see her in court today? Yes. Was the envelope sealed at the top? Was it sealed on both ends? I don't remember. I don't remember whether it was actually sealed shut or not. Was it folded? Yes. And the gasoline was in a plastic baggie, a plastic Ziploc baggie inside of the manila envelope. Did you see any gasoline on your hands at all? No, not that I remember. Had any of the matches ignited? No. How much of the cigarette was left? About 1.5 inches was left. Did you save the whole cigarette? After I had put the cigarette out, I put it in the trash can. Did you ever give it to the sheriffs? Yes, I did. And what about the envelope? Did you give that to the sheriffs as well? Yes. Did you see anyone else at your residence that day other than this large man that you saw from the back? No. When was the last time that Mr. Nixon talked to your mother prior to June 25? I don't remember. You indicated a couple of months prior to that time that Mr. Nixon was at the house and there was a problem at that time. Yes. Do you know whether he talked to her after that? I know there were a couple of phone conversations, but I can't remember whether those were after or before. Was your mother trying to break off the relationship with Mr. Nixon? From what I understand, my mother was trying to break it off.
That was difficult. Envelope. I always forget envelope. It doesn't come up in a lot, but when it does, I always blank on how to write it.
All right, now for a little voice practice.
Voice.
And we will start with the plaintiff.
Okay.
Ready? Prior to the happening of this accident, had you ever been involved in investigating any kind of an injury accident? Yes. And approximately how many injury accidents had you been involved in investigating before the accident? Approximately 15 injury collisions. And before the happening of this accident, had you been involved in investigating any property damage only accidents? Yes. And approximately how many had you been involved in before this accident? Approximately 75. Did you utilize any materials while you were at the academy? How can you explain that? Yeah, probably a bad question. And thanks for letting me know you didn't get it. While you were at the academy, did the instructors utilize any kind of PowerPoint, any kind of written materials, anything like at that? Yes. To train you? Yes. Would it be both PowerPoint and written materials? Correct. And with regard to the investigation of fatal accidents, did they use PowerPoint and written materials? Yes. Do you still have any of those written materials by chance? I don't. Okay. If I wanted to get copies of those to see what it is that the CHP trained with regard to the investigation of fatal accidents, who would I go see or check with? I believe you'd call our area office in Cyprus. Okay, and have you seen that they have copies of the materials that you used? I'm not sure of how the copies are distributed to the public. Okay, with regard to the investigation of the fatal accidents, tell me what it was that the CHP trained you to do as far as that investigation, those types of investigations. They trained me to go to the scene, document the collision, document the location of the evidence, speak with the witnesses, obtain their statements, document injuries to all parties, document damage to vehicles. Okay. Follow up with a significant other to find out a driver profile, which would be to help determine the state of mind of the driver prior to the collision, and document all on-scene emergency personnel as well as CHP employees. Okay. So you came out of the academy, and I know you were stationed at the Cypress Hills station there in Cyprus, correct? Yes. And do you go right away on patrol? You conduct it's approximately 3 months of field training with a field training officer. And that would bring us up to about July of 2013 or so. Yes. Okay. And did you have the 3 months of training? Yes. And who were your field training officers? My first field training officer was Officer Scott Strong. My second field training officer was Officer Susan Arnold, last name Arnold. My third field training officer was Officer Jim Morris, last name Morris. And about how long were you with Scott Strong? Approximately 1 month. It would be approximately 1 month for all of my field training officers for each. Okay. And did you cover the same thing with each one? Yes. And tell me what it was that you covered during your 3 months of field training. We covered vehicle dynamics, just learning how to drive the patrol car. We covered ticket writing, how to issue citations. We covered how to investigate traffic collisions and each officer's style of investigating traffic collisions. On my third phase with Officer Morris, we covered DUI investigations and officer safety issues with all three of them. And while you were doing the field training with the field training officers, approximately between April of 13 to July of 2014, did you have an occasion to ever go on patrol with them? Not with them as the driver. It was always myself as the driver and them being in an instruction role. Okay, you were still in kind of a mentee-mentor, correct, role, instructor-student kind of thing? Yes. Okay, while you were in that role, did you have an occasion to actually ride along with them while they were on patrol? Yes. All right. And what areas would be the areas that you'd be riding along with them while you were in the field training part of your training? The field training with each field training officer begins with one day of me riding with them in a patrol scenario where they were patrolling and I was observing them.
That's it for that. I did terribly on that second one. My hand's starting to hurt, that's why. Getting a little cramped.
This will be a 100 Q&A practice test. Plaintiff Attorney Mr. Thompson, capital THOMPSON. Defense Attorney Ms. MS period Andrews, capital ANDREWS.
Okay.
And we'll start with defense.
Defense.
Ready?
My poor hand.
As of March 2011, yes. Okay, and tell me what your job entails. What exactly do you do on a typical day? At present, my duties have changed over the years. Okay, let's go back then to the time of your injury around May of 2012 to March of 2013. Around that time, what were your, and immediately preceding that, what were your duties? Let's start between August 2012 and August 2013. Okay, all right, that's fine. So August 2013, my primary duties was that of the board secretary. And so you want to know what I did? Yeah, describe kind of what you did on a daily basis. Where do I start? It's a lot. Okay, so my duties as a board secretary, I prepared for our board meetings. How did you prepare? I would compile our board reports. So I would print all of the staff reports, compile them into binders. I reviewed the agenda. I reviewed staff reports. I occasionally did staff reports, created staff reports. Occasionally. How often would that be? The staff reports, when requested, I hard to say, not that often. Once a month, once a week, once maybe 2 times a year. 2 times a year? Yeah, okay. I gathered the materials for our board meetings, so once the binders were complete, I'd have to put them into tubs. And once they were in the tubs, I'd have to put them onto a dolly, along with the presentation equipment, the projector, laptop. We had the name plates which were placed in tubs. Those would go onto the dolly. Plates? You mean the plates that go on the tables for our board members. So I would put all of that onto the dolly, and I would have to drag the dolly out to the vehicle, load the vehicle with all the tubs, the dolly. How many tubs approximately would that be? 5 tubs. Do you have any idea approximately how much they weighed, or probably more than 30 pounds? Okay, and how often would you do that? Once a month. Okay, once a month. Okay, and then would you drive, except for the months that we didn't have board meetings? Okay. And would you drive it somewhere? Yes, we would take it to the location where we were having the board meeting. I would unload the vehicle, put all the materials, tubs back onto the dolly, drag it into the building, take the tubs off of the dolly, and set up for the board meeting. And then I take it you would do the same, then bringing it back, going back, correct. By then, are the tubs empty because the materials are passed out? No, the board reports remained in the fold, in the binders. I would just reload the tubs and go through the process.
Oh, that was only 5 minutes. I always forget. Only 5 minutes and my hand hurts. Okay, that's it for this stream. I did terribly on that one too. It was just difficult. It wasn't even 4 boys, it was only 3 boys. It started right at the beginning. I knew I would have a tough time when I missed words at the very, very beginning. Okay. Let's go ahead and raid Akiko. She's celebrating her anniversary. I'll be back tomorrow to play Yakuza Kiwami 2. Goodbye, everybody.